Are you a contractor, subcontractor, material supplier, or rental company? Have you provided work, materials, or equipment and still have not been paid? Here are 3 avenues of recovery you should consider. Enforce your construction contract. Record a construction lien and foreclose on it, or assert a payment bond claim and sue the surety. Let's discuss each in turn, but make sure to listen to the end as more than one avenue of recovery may be available to you. Let's start by talking about your contract. Whether you have an oral or written contract, the party that hired you may be ultimately liable for payment. Specific contract terms aside, here are some steps to increase the likelihood of getting paid. First, ensure that the debtor has all of the bills or payment applications you claim are due, including a final bill for any retainage, claims, delays, and the like. You can't expect someone to pay you if they don't have all your bills and payment applications. Next, you need to contact the debtor. Do it verbally and in writing. Nicely and firmly, but do it. And do the best you can to get the customer to start paying you. Unfortunately, once is usually not enough. Several calls and emails are probably required. Once you get a hold of them, if possible, resolve any disputes as to the goods or services immediately and in writing. It is almost always better to give a small credit in exchange for a payment and move on. If you do, expressly condition the credit on prompt payment by a date certain. Remember, leave your emotions at the door when you deal with credit and collection issues. It makes resolving a business dispute much easier and cheaper in the long run. Finally, once you determine that there's nothing more you can do yourself, don't wait to enforce your legal rights. Every day that goes by makes it that much harder to collect the debt. Contact a board-certified construction law expert right away. Now, let's talk about how to record a construction lien. In Florida, those that furnish labor, materials, or equipment for the demolition, design, construction, or improvement of private construction projects are generally entitled to a construction lien on the owner's property. Lien rights usually exist for contractors, subcontractors, sub-subcontractors, rental companies, material suppliers, and laborers. Of all the ways to secure your right to be paid, a lien is one of the best. Subject to the owner's defenses and any prior liens, the property may be sold at public auction and the liener could be paid in full, including all reasonable attorney's fees and costs. Securing your lien rights requires some planning ahead. No later than 45 days from your first work on the property, the owner, and possibly others, must receive your notice to owner by certified mail. This notice to owner must be sent even if you are not owed any money at the time. It is a critical prerequisite to having lien rights. Next, no later than 90 days of your last work on the project, you must record your claim of lien. The lien must be recorded in the county where the property is located. Within 15 days of recording the claim of lien, you must serve a copy of it on the owner and possibly others. If you have a contract with the owner, then the next step is to serve the owner with a contractor's final affidavit no later than 5 days before you file a lawsuit to foreclose on the lien. You can and should serve your contractor's final affidavit when you serve your claim of lien. Finally, no later than 1 year from the recording date of the claim of lien, you must file a foreclosure lawsuit in civil court. There are many exceptions that apply to all of these rules. Additionally, there may be circumstances that could shorten the time you have to serve your notice to owner, record your lien, and file the lawsuit. These legal formalities aside, the longer you wait to initiate collection efforts, the harder it is to get paid. Don't wait to enforce your legal rights. Contact a board-certified construction law expert right away. Finally, let's talk about how to assert a payment bond claim. In Florida, those that furnish labor, materials, or equipment for the demolition, construction, or improvement of bonded construction projects are generally entitled to seek recovery from the payment bond surety. Typically, the rights against the bond exist for subcontractors, sub-subcontractors, rental companies, material suppliers, and laborers. Subject to the surety's defenses, the bond claimant could be paid in full, including any reasonable attorney's fees and costs. Unlike a lien, a payment bond claim does not encumber the property. In fact, the purpose of the payment bond is to keep the property free of liens. Additionally, public property is not subject to liens, and generally the only recourse an unpaid claimant has is against the payment bond or the party that hired them. Securing your payment bond claim requires some planning. No later than 45 days from your first work on the property, the contractor and the surety must receive your notice to contractor by certified mail. This notice must be sent even if you are not owed any money at the time. It is a prerequisite to having rights against the bond. Next, no later than 90 days from your last work on the project, you must serve your notice of non-payment. Finally, no later than 1 year from your last work on the property, you must file a lawsuit against the payment bond surety in civil court. There are many exceptions that apply to all of these rules. Additionally, there may be circumstances that could shorten the time you have to serve your notice to contractor, notice of non-payment, and file the lawsuit. These legal formalities aside, the longer you wait to initiate collection efforts, the harder it is to get paid. Still have questions? Contact Alex Barthet, our board-certified construction law expert, right away.